Good afternoon. This is the last period. And I can't tell you how happy I am and enthused I am to be the last speaker of the day. You've had 2 meals today. And when I've been in your shoes before and I saw one speaker that was going to get up and talk for an hour or 50 minutes, I don't know about you, but it was hard for me to hold on to my will to live. And so what I'm hoping I can do for you today is to make this topic interesting, because for all of us who are teachers, this topic is extraordinarily interesting. It's also something, hopefully you'll see, I'm extraordinarily passionate about. And the reason is because as a teacher, it provides us with 3 opportunities for lessons. One of them is a history lesson. The other is a lesson in government, and the third is a lesson in citizenship. Now, the American jury, why is it important, and why would we be talking about it? Representative government and trial by jury are the heart and lungs of liberty. Without them, we would be ridden like horses, fleeced like sheep, worked like cattle, and dressed and fed like swine and hounds. John Adams, 1774. There are 2 times in our lives, in our government, where we truly are all equal. One of them is at the ballot box, and the other one is in the jury box. And that's a theme that I'm going to be sharing with you as we go through the day. But let's talk about history. Jury trials have a really, really rich and very important history that is filled with all sorts of twists and turns and strange happenings. Now, where does the American jury system come from? England, right? In the English system, where did it start? Where was the jury most important? When did it become most important to the English? You know, last year we celebrated the 800th anniversary of the Magna Carta. And one of the main tenets of the Magna Carta that survived almost all of its repeals and all of its changes and all of its deaths that it suffered all during those hundreds of years was the right to a trial by jury. Now, since the Magna Carta was written, the original one in 1215, they must have had a right to trial by jury before that. So where did that come from? And surprisingly, when you study this historical context of juries, you will find that the first juries were selected over 4,000 years ago in Egypt, of all places. And they had a system that they still use this word today in Egypt, but it's called a kenbet. We would spell it K-E-N-B-E-T. And what it was a system by which juries were selected, oftentimes from priests, but also from citizens. And they would select 8 of them to help judges decide facts. And the way they dispersed it in Egypt was 4 of them had to live on one side of the Nile and 4 of them had to live on the other side. And they would come together and make this determination. And so here we have this history of developing in the world of people, citizens, sitting in judgment on facts, and sometimes sitting on judgment of whether someone committed some sort of a crime. Now we fast forward about 1,500 years, and we find that the ancient Greeks, in their first experiments with democracy, the Athenians, they began having trials by jury. And what is one of the most famous trials of all the Athenian trials? Exactly, the trial of Socrates, 399 BC. And why is it famous? Well, one of the reasons is because the most accurate account of it was written by Plato. And the general thrust of what he was accused of is that they had experimented in Athens with democracy, and then they went in another direction, and they experimented again, and they went in another direction. And in one of the iterations of it, this newer democracy that they had, Socrates was, as you know, a philosopher. He was a very learned man, very respected, also very controversial. And he started speaking out about things he thought were wrong with the democracy, things he thought they should do better to make the democracy better and more representative. And they brought him to trial basically for sedition, before he was speaking out, and they were speaking out against the government, and they didn't want that. So they brought him to trial. They had this huge jury. And of course, he basically admitted that he had said all of those things, and the jury found him guilty. And he thought, and I think everyone that knew him thought, that the penalty would probably be some sort of financial penalty that he probably couldn't pay because he was really a poor man. And so there were a lot of people prepared to pay his fine, but much to their surprise, and certainly to the surprise of Socrates, the sentence that they were imposed upon him was death. Now, there was sort of a caveat there. If he would renounce that which he had said that got him in trouble in the first place, they could commute the sentence. And in this high principle decision that he made, he thought that what he said was true. He didn't necessarily agree with the verdict, obviously, but he felt such a strong conviction in the early stages of democracy in Athens that he wanted to respect the decision that the jury made. And as we all know, he took the poison and executed the death sentence himself because he believed so strongly in the jury system and the rights of citizens to speak. So then we come forward, and we don't know exactly when, but we know that the Athenians, the Greeks, they influenced the Romans. The Romans conquered England, came to England. Sir William Blackstone, who was a very learned jurist and legal writer in England, very, very famous, was knighted. He believes that England had juries as early as 829 they had juries. All of us know William the Conqueror came in what year? 1066. It's about the only date I remember in history, but 1066. And when he came, he brought the Frankish inquest, which was also a form of jury trials. So they had all these jury trials, but somehow or another, they got kind of abandoned. So that by 1215, when all the noblemen forced King John to sign the Magna Carta, it was very important that those be reinstated. And the Magna Carta originally said that no free man could be tried or have his property taken or his life taken away from him unless by a jury of his peers. And one would think that's where we have that connection today to being tried by a jury of our peers. Historically, however, it was totally different in England because the key word is free man. And there weren't hardly any free men in England at that time. You were either a noble or you weren't a free man. So it was basically the nobles who were trying to guarantee that they would be tried, and who would they be tried by? Other nobles. Because they didn't want to be tried either by the king or the king's representative. But the most important thing historically about the Magna Carta was, it was probably the first time in recorded history where the people, be they nobles or not, wanted a written guarantee that they would be entitled to a jury trial. So we move forward hundreds of years. The jury trial becomes very popular in England. It's exercised very, very frequently. They set up the law courts, as all of you know, and certainly any of you who've been there. They're ancient courts. So it's in that context that all of these English folks start coming across the ocean to the New World in the 1600s. And when they arrive there, they have an enormous amount of challenges. And one that you might not think of or appreciate, I certainly didn't until I started looking at this topic, was was that they didn't have a system of laws. They didn't have statutes. They didn't have common law, which is the law that's written and accepted as time goes on, because it was a totally new country. They had a government that was basically sort of imported from England, but there weren't any established statutes, rules, or regulations for the colonies. And so, but they did have juries. They used juries, and everyone accepted them. One of the things that Judge Rendell said today that I thought was most important, and it makes me happy as a person that participates in the judicial system, because it's almost always true, and that is that when a jury speaks, you may not like the result, and you may want to appeal the result, but you accept it. And for the most part, for literally hundreds of years, centuries, it's always been a peaceable result, a peaceable way of resolving conflict. And the colonials here in America, they were wild about the jury trial. Per capita, they had more jury trials then than we have now. It was very popular because that's the way they saw things. Your cow is on my land. Well, that's actually not your land, it's my land. Well, I want to sue you to get my cow back. Well, I'm going to sue you for trespassing on my land. They all came in. And the reason the jury trials were so important and popular is because the jurors who heard these cases were people who were citizens that usually knew who the litigants were. And so they could tell, because they knew them by name, reputation, otherwise, who's telling the truth, what's the real story here, what's the real equity here, what should we do, and what should we say, and what should our verdict reflect on how to resolve this dispute. And almost universally during that whole colonial period, jury trials worked really, really well. Now, this morning, our very first speaker, as you'll remember, Dr. Young, the professor from here in Philadelphia, he mentioned the case that is called the Zinger case, or Zinger. It's easier for me to say Zinger. In any event, he mentioned it very briefly, but it's really probably one of the most important cases in American history for a number of reasons. And you'll recall his explanation this morning is that we had a governor named Bill Cosby who came in for governor of New York. But let me tell you how he came, because it's kind of interesting. New York had a governor his name was Governor Van Dam, and he was the governor here in New York, and the king didn't like him. The King of England didn't like him. So he appointed a replacement, and the replacement was William Cosby, who was governor. So William Cosby comes across, and he shows up in New York to take over the governorship from Governor Van Dam. And the very first thing he says to Governor Van Dam is, by the way, I want you to pay me half of all of your earnings that you made as governor while I was coming over here. And Van Dam, we don't know for certain, but we think that his response probably rhymed with his name. He basically said, I'm not going to do that. So Governor Cosby sued him to get half that money. And he appointed, because he was the new governor, he appointed 2 of the 3 judges who was going to decide the case. And of course, the case was tried, and the 2 judges he appointed found that the money should be paid to Governor Cosby, and the one independent judge said no. His name was Morrison. He was actually the Chief Justice of the court there. And he said, no, that's just not right. But he had the 2 judges, Governor Cosby had the 2 judges seal all the records, all the testimony, so nobody knew what happened. And of all things, it was the Chief Justice, Morrison, who said, that's just not right. We ought to do something about that. So what he decided to do, he started a newspaper. And he started a newspaper there in New York. He tried to find somebody to publish it. Well, Mr. Zinger was a German immigrant who happened to have come over from Germany with a printing press. And he was making a living doing printing work. And so, of course, here's new business. He took Justice Morrison's comments about what happened in the trial and how wrong it was and how bad it was and how the public needed to know about all this. And what happens? Do they sue Justice Morrison? No, they sue poor Mr. Zinger. And he's just like, I'm just doing my job. And at that time, the law that England had sent over that we were kind of using at the time is that you could get sued for libel, and it didn't make any difference whether or not what you said was true. If you just said something that cast someone in a false light, you got sued for it, and you could actually go to prison for it. So to tell you how important American juries are, they tried this case, and poor Mr. Zinger, he hires a lawyer, and the governor has that lawyer disbarred. So he hires another lawyer, and the governor has that lawyer disbarred. And then the governor appoints a lawyer to represent Mr. Zinger. And in the great tradition that all of us lawyers would be proud to serve, we had a lawyer who, notwithstanding who appointed him or who paid him, he was an ethical lawyer. And he thought his first duty, his first and only duty, was to his client. And so he asked for a jury trial. And of course, the judge who was appointed to hear the case, his fix was in. The governor thought, I've appointed the lawyer, my fix is in. The lawyer starts arguing about a jury and wants a really fair and impartial jury. The judge finally gives up and lets him in panel one. And this third lawyer, he's a good ethical lawyer, but he's not a very good trial lawyer. So right as the trial starts, he stands up in open court. This would make a great movie scene. He stands up in open court with this whole gallery full of people, and he says, Your Honor, I am withdrawing from the representation of Mr. Zinger. And he walks off. A lawyer rises from the audience. His name is Andrew Hamilton, not Alexander Hamilton, the star of Broadway, but his name was Andrew Hamilton. And he walks up, this is all prearranged, he walks up, takes over the defense of Mr. Zinger. And that particular Hamilton lawyer happened to be probably the best lawyer who was living in the 1700s. He did a magnificent job defending Mr. Zinger. And even though the judge charged the jury that the law is, if he printed it and it cast somebody alive, he's guilty, Hamilton argued that the jurors were the conscience of the community. The jurors had an obligation not only to decide whether or not someone was guilty or innocent, but to decide whether or not the law that they were being asked to rule on was the right one and the right interpretation of it. And he said it was a basic new American principle that surely you could not be punished for doing something that was simply telling the truth. And if he told the truth, and that was all he was being charged for, was for printing the truth, he could not be found guilty of libel. The jury was out for less than an hour and came back with a verdict of not guilty. And there are a number of legal scholars who studied this issue and studied American law and American jurisprudence and the Revolution. And they say that this trial, the publicity, the results, and what that jury did was really the seed or the catalyst for the American Revolution, because it instilled in the minds of the citizens that there is some greater object, some greater purpose, some better source of our citizenship than what England and a king tells us. It's what we tell and can do for ourselves. And so that's why they started the ball rolling. Then the other issue that came up, Britain was pretty sneaky. They decided that they needed money and they wanted to tax the colonists. And so what they did is they passed the Stamp Act. And the Stamp Act was an act that said any paper that you use or purchase has to have a stamp on it. And of course, they charge you for the stamps. And so they were charging stamps on legal documents, deeds, wills, suit papers. They were charging it on any sort of wrapping paper, newspaper, books, playing cards, dice. I don't know how dice was paper, but anyway, they charged dice. And so they passed this tax, but they also said as part of the act that you're not entitled to a jury trial. Because the king said, the last time I was involved in one of those, it didn't go so well for me. So the colonists start the Stamp Act Congress. In this Stamp Act Congress, one of the very first things they said was, every subject, every British English subject is entitled by right to a trial by jury, and you are depriving us of that right. John Adams wrote about it, Thomas Jefferson wrote about it, and it was the spark or the kindling of two things. You're taxing us without our permission or representation, and you're depriving us of a jury trial right. And so this was in 1755 or so. It was long before the Lexington or Concord or any of those things. It was before the Boston Tea Party. And it was the real catalyst that started people thinking. And they were already writing it down. The Stamp Act Congress, we have an inherent right to a trial by jury. So when Thomas Jefferson wrote the Declaration of Independence, along with the collaborators that he had, one of the very first principles he put there was that very thing. We citizens are entitled to have our disputes determined by citizens, by citizen juries, by a right of trial by jury. So those things that you've heard all of your life that men and women have fought for and died for these principles, it's not a hopeful thing. It's not a suggestive thing. It is an absolute fact. That was one of the real principles that they fought and died for. Now, the other thing that's happened in American history is they fought the Revolution, and they found out after the Revolution was over that fighting was actually pretty easy. The real struggle was trying to govern ourselves. And you've heard a lot about that this morning. And they went through the Congress, and they were over there 2 blocks away trying to write a constitution here years after the Revolution was over. And they were wrestling with all of these concepts. And then they came up with a constitution, and it actually had a provision in it about trial by jury. But they put it to the people, and the people wouldn't ratify it because there weren't the written guarantees, just like the Magna Carta. They didn't have sufficient written guarantees to guarantee them trial by jury. And we've heard today that the trial by jury rights mentioned twice in the Bill of Rights. Actually, jury is mentioned 3 times in the Bill of Rights. It's in the 5th Amendment to the Bill of Rights. It talks about the grand jury in criminal cases. It's in the 6th Amendment for criminal cases, and it's in the 7th Amendment for civil cases. And ABOTA is a 7th Amendment organization because we're all civil lawyers. But for us, the right of trial by jury in civil or criminal cases is so valuable, so inherent, and such a guardian of our rights for a whole number of reasons. So that's the history of how all of these things came into being. And as you all know from history, is that colonists would not ratify the Constitution until it had those 10 Bill of Rights included in there. Now, of those 10, just think about this for a second, if you want to know how valuable this right is. The last 2 of the 10 amendments basically concern, we don't mean to impinge upon any rights that you have as common law. That's 9. And 10 is basically that any law that we don't specifically exclude that except belongs to the states. So we have 8 amendments left. One of those, if you'll recall, the First Amendment from our story of Mr. Zinger, freedom of speech, expression, that was one that they found as a result of a jury trial. So you could argue there's 4 of those 8 substantive amendments to the Bill of Rights that had something to do specifically with a jury or as a result of what a jury did. But then there's those 3, the grand jury, criminal cases, civil cases. So now, let's move to our lesson on government. And I watched this jaywalking sometime when Jay Leno was on on TV, and they have others now where they're basically asking students, they're asking middle-aged people, they're asking young people questions about government. What are the three branches of government? You give them a multiple choice question, okay? And it has the right answers there. And the overwhelming majority of them answer that the three branches of government are Republican, Democrat, and Independent. Scary, isn't it? We're not teaching these young students, because so many places don't have civics, but we're not teaching them that there are three branches of government and that it was the real genius of all of those framers of the Constitution. It's been the real genius of the success of our country that we had those three supposed to be co-equal branches of government that checks and balances system between the government that was supposed to work so well. And the thing that's so important is that the jury system was inherent in that, in the judicial system. Judge Young, who will speak to you tomorrow, may mention to you, because he's written about it frequently and talked about it, that in the context of our government, there's really like 6 officials or groups of officials in government. On the legislative side, there are senators and congressmen. On the executive side, there's the president and the vice president. And on the judicial side, there are judges and jurors. So that those judges and jurors in the judicial part of our government are 2 of the most important officials that we have in our government. So we go to citizenship. And again, I come back to there's 2 great equalizers in our country where everyone has the same rights. And that's at the ballot box and in the jury box. And from a citizenship standpoint, every citizen has the right to have their guilt or innocence in a criminal case decided by a jury and have their civil dispute decided by a jury. Every citizen. In addition to that, every citizen has the right, and we all think the obligation, to serve on a jury. And we also have a problem with that in our country. People get a jury summons and they toss it in the round file cabinet. They don't show up for jury service. And the real thing that we need to be instilling in all of our young folks is that this right is so valuable, it's so important, it is such a great protection for us from government intervention, that the only way that system works is if we do participate, if we vote and we sit as jurors. Because think about it, there may be a time in your life when you least expect it, when you become a defendant or a plaintiff in a civil case or a defendant in a criminal case, wrongfully accused. And the question you should be asking yourself from a civic standpoint, a citizen standpoint, is what kind of jury would I like to have? And would I like to have someone as intelligent and as reasonable and as thoughtful and as informed as I on my own jury? Because if we don't participate and we don't get people to participate, then either no one will be participating, or the ones that are participating you might not want as jurors in your case. So this is one of the real critical lessons, I think, for all of us that are involved in this system and for all of us who have the opportunity to use it. Now, from a lawyer's standpoint and a lawyer's perspective, I can tell you that one of the criticisms, of course, that everyone hears about juries, or that they're wild and crazy and they do these terrible things, and you read about these headlines where jurors have given some outlandish verdict for some reason. Mike mentioned to you that I was prosecuted criminal cases. So I prosecuted hundreds of criminal cases. I have defended criminal cases. I prosecuted as a plaintiff civil cases and defended civil cases. And I can tell you that of all of those cases I've been involved in, all the cases I've watched other lawyers try, with just a single or maybe two exceptions, every time a verdict came back, I understood exactly why and thought it was the right decision. Even when I didn't like it, or it wasn't good for my client, or it wasn't good for the state of Texas, I thought that it was what should have happened. Because one of the things that happens to all of us as lawyers is we get tunnel vision. We get a case, we're all involved in it, we're looking at it, and it becomes very important, and our vision sometimes kind of shrinks down a little bit, and we can't see what the facts are. And ordinarily, the jury always comes back and they tell you what the facts are, and when you hear them, almost always you respect them. Even if you don't like the result, you always, always respect them. Now, you have a little flyer or little pamphlet in your notebook there that has what would cars be like without the civil justice system. And I can tell you that this was prepared by the American Association for Justice. And you can argue that this is a plaintiff's diagram. But I'm bringing it up to you, and I ask you to kind of look at it for a minute, because it can reveal a lot about how powerful juries are and how much change they can bring about. Because all of the things that are listed here that are improvements to all of our vehicles that we rely upon to safely maneuver the streets and highways in the United States are things that happen as a result of a jury verdict. And I can share with you, because it's a matter of public record, I've represented auto manufacturers, I've represented aircraft manufacturers, I've represented pharmaceutical manufacturers, and I can tell you that they don't often come in and decide that these kinds of things. Usually a trial lawyer takes it and a jury makes a determination. Ford Pinto was a very dangerous automobile. It had an exploding gas tank. If you got hit in the rear, even at low speed, it would explode and it would burn people very badly. Ford actually had a memo that they had written by one of their accountants, in-house accounting people, that calculated probably how many accidents and explosions were going to occur. And based on those explosions, they figured probably there'll be hundreds of deaths, there'll be lots of serious burns, and there'll be lots of these. And we can probably settle these cases for this amount, and this amount, and this amount, and it all totals up over here. If we have a recall for all of these cars, it's going to cost us all of this money. It's going to cost us a whole lot more money to recall than it will to pay for all the burn people. So it was a lawyer and a jury that made Ford change that design. It just happened to be an ABOTA lawyer in the 1970s that did that. It was an ABOTA lawyer that had a jury answer a call on a General Motors school bus that had burned a lot of school children to death because they had a cage around their gas tank that wasn't sufficient on impact to protect the gas tank. Pharmaceutical cases, you can go on and on and on. And the fact of the matter is that it is oftentimes juries are the potential for a jury, because it's very hard to trick a jury, very, very hard. And people know that if a jury sees this evidence or hears this evidence, they won't like it. You know, you might remember Aaron Andrews, that was an ESPN reporter who a hotel gave a stalker her room number and allowed him to book a room next to her so he could take pictures of her in a state of undress in her room. And it was a jury that told the hotels that you don't do that. You don't give out people's rooms and room numbers and names or confirm that they're there. Jury did that. Hotels didn't decide that, jury decided that. Recently in the news, you have the Fox reporter, Gretchen, I can't remember her last name, Carlson. She had an arbitration agreement with Fox that said that if she had some problem with Fox, she'd have to arbitrate it. And arbitration is a private proceeding, and you don't know the results, and you don't hear the results, and you don't hear the testimony or see the testimony or anything else. And that's what Fox preferred. Well, Gretchen had a lawyer who didn't sue Fox. They sued Roger Ailes personally. And they've been entitled to a jury trial on that. And because of the information and evidence that they had, Roger Ailes and Fox decided they'd settle that case rather than go to a jury because they didn't want the jury to hear that. Same thing with Volkswagen. Volkswagen, you know, has a problem with all their diesel emissions and so forth. It's a mass tort case pending in California that was settled probably more quickly after filing, just in a matter of months, than any mass tort case has ever been settled. And I think the primary reason for that is that they didn't want to face a jury with the evidence that they'd actually manufactured a part that would sneak by the emissions test and emissions standards. They actually manufactured it and installed it in the car and didn't tell anybody. So that's the purpose of juries. That's the purpose of having them there to decide those disputes, because sometimes people don't feel comfortable with having a judge decide it. Judge hears these kinds of things all the time. Sometimes they have long trials, short trials. Sometimes they make the right decision, sometimes they don't. But the one really interesting aspect about the juries are that there's agencies that study these verdicts. There's the National Center for State Courts, and there's a lot of others that get all this empirical data, and they look at jury verdicts, and they interview the judges in the courts who these cases were tried, and in an overwhelming percentage of cases, the judges say, I think the jury got it exactly right. On the small percentage of cases where the judge disagreed with the jury verdict, believe it or not, often the judge says, well, I think I would have given them more money. And then there are other times where the judge just says, I don't think I would have awarded that, or I wouldn't have found for that party. But an overwhelming number. So the juries almost always get it right. When the judge from the Third Court of Appeals, Federal Court of Appeals, spoke to you today, she mentioned the Cold War, and she said, well, I don't know, a lot of you probably have students that don't know what the Cold War was or is. I'm gonna close with a quote from a movie. I'm an old fan, or a fan of old black and white movies. And there's an old black and white movie about a trial. Jimmy Stewart was in it. It was called Anatomy of a Murder. Jimmy Stewart, Ben Gazzara, there were a bunch of, George C. Scott was in it. And there's this one great quote, I think, that has something to do about juries and why juries are important. Jimmy Stewart is a lawyer, and there's an old lawyer named Emmett McCarthy who's trying to get Jimmy to join a partnership with him. And Emmett was going to represent this criminal defendant who's Ben Gazzara in a case, but he gets injured and asks Jimmy Stewart if he'd do it. So Jimmy Stewart does it, and so they've tried the case, very contentious case, very dramatic case. I recommend the movie to you. It's a wonderful movie. And so the jury is out deliberating. And so they walk down to Jimmy Stewart's house, and he's there playing the piano, waiting for the jury verdict to come in. And his secretary is Eve Arden, I believe, who played our Miss Brooks. She's his secretary, and old Emmett is sitting over in a chair. And they're talking about the jury, and she says, what do you think the jury's going to do? And Jimmy Stewart says, I don't know. I just hope they do the right thing. And Emmett McCarthy, this old lawyer, he looks up, and he's in a rocking chair, and he's kind of rocking back and forth, and he says this. He said, jury. He said, 12 people go off in a room, 12 different minds, 12 different hearts, 12 different walks of life, 12 sets of eyes, ears, shapes, and sizes. And these 12 people are asked to judge another human being as different from them as they are from each other. And in their judgment, they must come to one conclusion. It is one of the miracles of man's disorganized soul that they can do it, and they do it right well. God bless juries. And so for all of us, and this is an editorial comment for us, but God bless juries, and may they always be the guardian of our rights. Thank you.